basically a form with alternative provisions. We'll walk through, you'll see what I'm saying. First thing we've got to do, of course, if you're doing land contracts, I'm going to assume you're going to still have a title agency close it. If you're not going to, if you're going to do it like we did in the 80s, then we have to be much more precise. All right? If you look at the land contract form, you got the seller and the purchaser. Well, we need to make certain that the proper names are there, because that's the name that's going to show up on the deed. I mean, right now, you know, the way we've done it, we kind of like sign the purchase agreement, whatever, and the title company cleans it up for us. If, in fact, people are going to do land contracts and going to leave it in our hands, we've got to make sure we start with that for basic accuracy. All right. Same thing with the legal description. We have people, again, on purchase agreements, they'll pull off a legal for the tax parcel legal. All right. I don't know what your experience has been with tax parcel legals, but I can tell you in Central Michigan, they're usually incomplete and sometimes are inaccurate. So you're going to want to make sure you've got the appropriate legal description to go into land contract. Shouldn't be a problem. Shouldn't be a problem because as part of this deal, as part of the purchase agreement, of course, the seller's going to agree to provide title insurance to the buyer. And of course, the title commitment is going to set forth the legal. We just got to make sure it gets plugged in here. Okay? Now, we move to paragraph 2, and that's the first time we run into a potential issue between a seller and a buyer. If you look at paragraph 2, there's a couple of issues in there. It starts out setting forth the purchase price. That's not a problem. And then we're going to have the down payment. Now, again, if you're representing sellers or representing buyers, you obviously have different objectives when it comes to the down payment. One reason that I think land contracts worked as well as they did in the early 80s is we had people who had substantial down payments, 10%, 20%. They just couldn't afford the 17%. So they would end up putting 10 to 20% of the purchase price up as a down payment. Now, why is that meaningful? Well, if we have a situation now where we've got somebody who's a buyer and they want to buy a house and land contract and they're looking at the seller and they tell the seller, I want to put $1,000 down on a $300,000 land contract purchase instead of $30,000 down. The common belief is, and I know it for fact, is if things go the least bit sideways for them, bye. They're gone. $1,000 is gone. So that's an issue we're going to be struggling with if we're going to use land contracts, because traditionally you try to get a fairly decent chunk up front for something that the buyer will strive to protect. So the down payment's going to be an issue. Obviously, the more the seller can get the buyer to put in it, the more the buyer can, the better off we are. Okay, then it talks about the remaining balance to be paid in monthly installments. You're going to have an issue between the buyer and the seller as to what amortization are you going to use. You're going to amortize this over 10 years, 15 years, 30 years, whatever you want. It's the same computer program we use now for mortgages. All right, so that's going to, in part, be driven by what's the monthly payment going to be. And the seller may have certain requirements they're going to need for a monthly payment. If you're representing them, you're going to need to know that. If, in fact, this is the house they couldn't sell after they bought this one over here, that means they've got a mortgage they're paying on over there.
Doesn't that mean we can't be involved?
Well, we'll get there.
Okay.
Oh, I'm sorry. I'm supposed to. No, we won't do that one. Okay. She wants to jump to due on sale. We'll get there. We'll get there. Okay. So anyway, that's what's one of the things driving this is what does the seller need per month, as well as what can the buyer afford per month. Now, an issue comes up where it says remaining balance of blank dollars to be paid in monthly installments of. And then it says including interest. There's some words missing there. I didn't put it in here because it's a neutral contract. Can the buyer make prepayments? Okay? They can't on this form. They can if the words or more are between the blank and including. Okay? That has been around forever. The case law is clear. If it says or more, then they can make any payment that they want. And you say, well, why would a seller be against prepayment? Well, let's assume we do one of these next week, and you've got a buyer who's agreed to pay 8% interest, 9% interest over 5 years, and interest rates fall to 4%. Seller doesn't want to be prepaid. They can't make that kind of interest rate on their money. So we actually did have those battles in the 80s when interest rates fell in about 1985. We had a bunch of land contracts out there at 11%, and all of a sudden they said, "No, I want to refinance. I can refinance this and get a 6% interest rate." So we ended up with battles over whether they could prepay or not. If you're representing the buyer, you want to make sure "or more" is in there, okay, and put it in there. Now, this particular provision calls for a balloon payment. If you look at it, it says first day of each month thereafter until blank 2000, at which time the entire balance of principal and interest, accrued interest, shall be due and payable. That's absolutely not necessary. Okay, I mean, we did these land contracts in the early 80s making a bet. And the bet was 3 years from now interest rates will be down. And that's the bet we made. And so they plugged in balloon payments. The seller wants to get out of this as soon as they can. But we want to get sufficient time. I assume here we're going to be, in some situations, looking at how much time does the buyer need to heal their credit. And that's an issue that I don't pretend to know the answer to that, but that's the decision they and the seller would have to come to agreement on. Then you would set up a balloon payment. Okay, we're going to amortize this as if it's a payment over 30 years. Interest rate's going to be 6.5%, 7%, but at the end of X, say 4 years, it's all due and payable. And so what the bet we're making there is, of course, is that the whatever the problem is, the house will appraise for more, the buyer's credit is healed, interest rates are affordable. That's the bet the buyer's making. And the seller's making it too, because they don't want the house back. But we need to understand that's the way that's going to work. And that's really what drives this balloon period. You could make it a 15-year land contract, amortize it over 15 years, and have no balloon at all. Most sellers don't want to do that, and most buyers don't want to do that, but there's nothing in the law that says you can't do that. Okay? All right, so those are kind of like 3 or 4 issues just in that one paragraph, number 2. Now, the interest rate, let's talk briefly about the interest rate. Generally, under most circumstances, the interest rate cannot exceed 11%. All right, if you're going above 11, or it looks like you're going to go above 11, go talk to an attorney. Okay, because then you start getting into usury issues. And if the penalty in Michigan is this: if I sign a land contract with you that indicates I'm going to pay you for 5 years, and then there's going to be a balloon, and somehow we have played with the interest provisions, so somehow it's 12%. All right? Well, all of a sudden, it's usurious. What does that mean? I don't have to pay you any more interest. Now, whatever I paid you for interest to date, I've waived that, but I don't have to pay you any more. And that's painful. It happened in the 80s a few times, and the sellers weren't happy about it. In fact, there were lawsuits over who made me charge this usurious interest rate. So again, if you're going to go above 11%, it can float. I don't recommend floating because most people have no clue how to calculate it. I mean, I love these exotic interest provisions. Well, we'll adjust it every 3 months on the prime is published in the Wall Street Journal on the second Tuesday of each month. And you'll weighted average of 3 months and blah, 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 and it's like no one can figure out what it means. Let me suggest to you, unless you're dealing with very sophisticated people, we agree upon an interest rate, and that's the rate. And if it's going to be adjusted, have it be adjusted. It can never exceed 11, but have it be adjusted every year or something that's a pretty easy way to determine it if you are going to go to an adjustable rate. Okay. All right. Now, that basically takes care of paragraph 2. That's a lot of issues in one single little paragraph, but it's all there. Paragraph number 3 is a reminder. Possession of the premises shall be delivered to purchaser at closing, subject only to. That's what makes, in part, a Michigan line contract so unique, is we are delivering possession at